This is Paul Turner, the immigration barrister at Imperium Chambers. This is an update on Balajigari and the fallout from the litigation. Now, we all know that the applicants won in Balajigari, and we all know that there was a hearing where cases were stayed and that the Home Office would put forward their position statement. That's very important. The position statement broadly was that where cases fell under the Balajigari cohort in the Upper Tribunal and the Court of Appeal, the Secretary of State would agree to reconsider, and the Secretary of State would agree to pay the applicant's costs, and that the applicant would have would then withdraw the judicial review. There was no qualification in the Secretary of State's position statements as to the costs. It was quite simply that the Secretary of State or the respondent pay the applicant's reasonable costs. What has happened since then seems to be that there is some confusion in the way that the Secretary of State is approaching this matter. Now, I've seen a number of consent orders that have come through from the Court of Appeal where the Secretary of State is saying that the cost shouldn't be awarded at all, and that's clearly against the position statement. I've also seen cases where the Secretary of State, in respect of upper tribunal cases, has agreed to pay costs, and in those cases that's not been an issue. I've also had cases where the Secretary of State has initially disagreed in respect and said that there should be no order as to costs, but we've argued that costs should be paid, and the Secretary of State's agreed. But I've also seen cases where the Secretary of State is saying that costs should only be awarded to the applicant after the case of Balajigari was decided, and also cases where the Secretary of State is saying that costs should only be awarded after grounds were amended, and also cases where the Secretary of State maintains that there should be no order as to costs. Now, this, quite frankly, is a mess, and the importance of this is that the Secretary of State seems to be changing the position as to whether or not and in what circumstances costs should be paid. Why this, I say, is important is not only does it affect the individuals and what they can recover, but it also affects the way that the upper tribunal is deciding cases, because the purpose of the position statement was so that the upper tribunal could form a view as to how cases were going to be disposed of. Now, the way the Secretary of State what the Secretary of State told the upper tribunal was, as I've said, that the decisions would be withdrawn, individuals would have their cases reconsidered, and they would recover their costs. And on that basis, the upper tribunal has either been granting permission or, strangely, refusing permission on the basis that the Secretary of State has agreed to reconsider, as per the position statement. Now, in respect of the upper tribunal, it's confusing that some judges are granting permission as a result of the Secretary of State's permission statement, and some judges are refusing permission on the basis that there will be a reconsideration in the future. That's not helpful, and if that's happened to you, I would say seek the advice of your representatives. In respect of the position of costs, what I would suggest is that you seek the help of your representatives, and that your representatives go back to the Secretary of State and put to the Secretary of State the following propositions. Firstly, that the manner in which the upper tribunal and Court of Appeal are dealing with these cases is to some extent, arguably, predicated upon the Secretary of State's position statement, i.e. withdrawal and payment of costs, and not on withdrawal, no payment of costs, or withdrawal and only limited payment of costs. And what I would, the argument that costs should only be paid from the date of Balajigari, I would suggest is a fallacious argument, one that doesn't bear scrutiny. And the reason for that is essentially, what I would argue, is that Balajigari didn't create the law. In English jurisprudence, the courts don't make the law, they interpret the law. So all Balajigari did was identify that the decision-making process was flawed. It identified that the way that the Secretary of State had proceeded was unlawful. So arguably, whether or not that was initially pleaded isn't relevant. That's the first point. But in any event, it goes against the Secretary of State's stated case in their position statement, which they put to the upper tribunal, and on which basis the upper tribunal is disposing of cases. So really at the moment it's a mess. We've got cases where the upper tribunal are granting permission, cases where the upper tribunal are refusing permission, cases where the Secretary of State's offering no costs, is paying all the costs, or is trying to get out of paying costs, or trying to limit the amount of costs. It's really a mess. But what I would say is that unless you've got everything that you could expect, which essentially is your reconsideration and your full costs for the judicial review and Court of Appeal hearing, then you ought to contact your lawyer and get your lawyer to make written representations to the Home Office on the basis of the Secretary of State's position statement and the underlying principle that Balajigari didn't make the law, it merely interpreted it or identified the law and used that as a basis for claiming costs. As I say, the position is very confused, and it seems that the Secretary of State is going back on her word, which is again regrettable, and it seems to me that what has perhaps happened is the Secretary of State has recognised that there are a great number of cases and that the initial offer to pay costs is going to prove very expensive. That, however, shouldn't be a matter of concern to individuals who've won their judicial reviews. As I say, this has been a short update. People have asked for information. If you've got any questions or you've got an immigration problem, please don't hesitate to contact me, Paul Turner, the immigration barrister at Imperium Chambers, on 0207 242 3488 or clerks@imperiumchambers.co.uk or at my website, The Immigration Barrister. Thank you for watching. I wish I could have given more clearer news or identified a clear way forward, but I think the only way forward is to take each case as it comes and to, if you're an applicant, to speak to your representatives. And as I say, if anyone has any problems, please do not hesitate to contact me. Thank you for watching. This has been Paul Turner, the Immigration Barrister at Imperium Chambers.